We all know that the general thrust of the lawyer's job is to advise on what is permitted under the law and what is not.
Help clients navigate our often unfairly complex legal system. But what about changing the law? Is a duty to develop and improve the law part of a lawyer's already long list of obligations? Should lawyers be activists? Our legal system comes from England, where judges decided what was fair and created precedents to help establish consistency. The body of precedents can only develop and change when someone challenges the law.
Therefore, it must be part of the lawyer's role to bring legal challenges, to keep the law alive and growing with society. Otherwise, the law would stagnate.
And in many areas, it has.
So the real question is, how much time should lawyers dedicate to legal activism? And how is this to be reconciled with their other duties?
Many lawyers may only challenge the law when it is in the commercial interests of their client to do so. They would argue that lawyers who are strongly influenced by moral concerns lose their objectivity and independence because the case becomes their cause.
If a lawyer's primary purpose is to be an advocate, then cherry-picking clients for the cause would leave some people without representation.
But what should come first? The needs of individuals or a fair and just society? However, if lawyers thought only of clients, then all changes and improvements to the law would be concentrated in the areas of highest demand. And to some extent, this explains why we have a very developed set of commercial laws and very little clarity on human rights. Lawyers have a paramount duty to the law, which, as I have explained, is inherently dynamic.
Therefore, the duty must be to the dynamic law, not just the law as it exists. If you accept that the static law may not be just, then a duty to justice and the law requires that lawyers take action.
Lawyers that follow this approach are often called moral activists, a term coined by American ethicist David Luban. Such lawyers exercise their own ideals in determining which areas of law require improvement. But what about some objective standards for improving the law? To clearly spell out this duty, there needs to be certainty.
Is it even possible to hold objective ideals without being influenced by community values? Now that's a topic for a whole nother video, but we can start with the fundamental precepts of our legal system.
The rule of law, the principles of legality, consistency, natural justice. Now, this isn't enough to set out a moral code for all circumstances, and lawyers must still take many ethical decisions for themselves. But there is a moral foundation to our justice system, which is outlined for us in the case law.
Perhaps as officers of the court, we should start paying a bit more attention to them and take our legal system, its nature, and fundamental principles into account when making ethical considerations.